Louisiana Governor Jeff Landry. Back when he won, again, I was talking about how this was going to be an example to the nation as to what happens when we go full Republican. It's going to be a warning sign to the majority of this country, to the vast majority of this country, as to what happens if if you have a government that is fully run by Republicans and the Democrats can't do anything but stand there and try and put up amendments to bills and then fail because they don't have the votes to do it. So in yesterday's or Monday's show, we talked a little bit about some of the stuff that Jeff Landry was trying to do and all of the stuff he's trying to pass and trying to make Louisiana look bad because, he wants this little dictatorship. He wants full and complete control. So the first one of there are 6 bills filed by Louisiana's Governor Jeff Landry, the moron, i.e. moron Jeff Landry, if you didn't get that. He wants more control over state government than any of his recent predecessors. 2 proposed constitutional amendments, so this is at least going to take the people to vote on it, would allow Jeff Landry to pick most members of the Louisiana Supreme Court and state civil service commissions, which oversees the hiring and firing of state workers. So instead of having some nice separation of powers where the Supreme Court are elected by the people of our state, they're going to put more power give to Landry by letting him pick the Supreme Court justices and also have him name the Civil Service Commission, or at least most of them. Another bill gives Jeff Landry control over the Louisiana Board of Ethics. And why does he want this? Because Jeff Landry took a private flight from a campaign donor in the fall, and he ran afoul of the Louisiana Board of Ethics. So what is the answer? It's not to just stop doing unethical things, but he just wants to take control of the Board of Ethics so that presumably he can do whatever he wants and not have them question him. There's legislation to empower Landry to pick chairpersons and other officers of hundreds of other state boards and commissions. So before, how it used to happen is that you'd have universities, like a combination of universities would suggest people who should be sitting on these state boards and commissions, and then from those people the governor would pick, and then it would go there. Now he wants to get rid of that, and he wants to get rid of the hearing other people's opinions and just wants to put people who I'm assuming are going to just be his lackeys in these other state boards and commissions. Most lawmakers who drafted the bills, according to LAilluminator.com, says that Landry is not pushing the proposals, though the sponsors include some of the governor's most biggest supporters in the legislature, i.e., there might not be a complete link of, oh, here, I'm Jeff Landry, I want you to vote for this, and them going, okay, we're gonna put this up for a vote, but you know how it works. Landry's office did not respond Wednesday when asked if he was supporting any of the legislation. Critics describe the bills as a callback to the Huey Long era. Most people think Louisiana governor is more powerful than any other governor, said Terry Ryder, who served as general counsel to former governors Mike Foster and Kathleen Blanco, Foster being a Republican, Blanco being a Democrat. I don't recall ever feeling like we didn't have the authority to run the state in the governor's office. This is what dictators do. Public Affairs Research Council of Louisiana expressed reservations over 2 of the members. The civil service and ethics boards are designed to be insulated from politics. It's not perfect, but what I would be concerned with any move that would result in the politicization of these boards, said Stephen Procopio, the head of the organization, in a statement on Wednesday. Senate Bill 497, the state ethics board's appointments, bill from Blake Miguez, a Republican from New Iberia, Louisiana, would allow the governor of the Louisiana House and State Senate to pick whoever they want to serve on the 11-member state ethics board. And of course, the Louisiana House and State Senate are currently completely controlled with supermajorities by Republicans. Under current law, they have to select members from lists of nominees the presidents of Louisiana's private universities and colleges compile, i.e., they don't have carte blanche to just pick anybody they want to. They have to get input from other people. The Republicans in Louisiana don't want input from other people. They want to run this stuff all by themselves and have nobody standing in their way of doing it, whatever it is that they want to do. Last fall, the board voted to penalize Landry for not disclosing that he had used a campaign donor's private plane to go to a work conference in Hawaii as Louisiana's Attorney General. The case remains unresolved as Landry and the Ethics Board continue to discuss what fines he might pay. In 2022, the Ethics Board concluded Landry violated the law by using campaign funds to reimburse himself for a Chevy Suburban he bought. Candidates are not allowed to use campaign money to purchase immovable property or vehicles. In that case, the Ethics Board chose to not fine Landry and initially kept the matter confidential. Miguez said Landry did not ask him to draft the legislation. State Civil Service Control. Jay Morris of Monroe, Louisiana, sponsored the constitutional amendment that would give the governor control of nearly all members of the Civil Service Commission. Under current law, the governor has to pick 6 commission appointments from lists some of the state's private universities and college presidents provide. Classified state employees elect the 7th member of the commission from their own ranks. Morris's proposal would do away with the university president's involvement, letting Landry select most of the commission by himself as long as the state senate agrees to confirm them. And since the state senate is currently in a supermajority of Republicans, there's no way that they're going to stand in his way. His bill also adds 3 at-large members for the governor to choose, giving the state leader control of 10 of 11 commission seats in total, taking away the power of the one that comes from classified state employees. The bill would limit the amount of time a person could spend on the commission from 10 to 8 years. Commission terms would be shortened from 6 to 4. Landry did not ask Morris to file legislation, although the senator said he talked to the governor about the proposal. Morris does not support having civil service, which he says can interfere with state agency efficiency by providing too many workforce protections. Oh no! See, there you go. This is Republicans saying the quiet stuff out loud. Because now they have full control, they can do whatever they want. They don't want too many workplace protections? Give me a break. He says, I could probably see us doing without civil service altogether. This is what you get when you go full Republican, people. Never go full Republican. Say what you want about the Democrats and whatever corruption they might have going on, and of course the corruption is bad, but you're not going to see Democrats trying to get away with civil or remove civil service. Civil Service Commission establishes guidelines for the state's 38,000 classified employees and is involved in the hiring and firing processes for government workers. The system will arguably no longer be apolitical if this proposal takes effect. Louisiana State and Government Affairs Committee on Wednesday voted 4-2 in favor of the legislation. As a constitutional amendment, Morris's bill needs a 2/3 majority of each chamber of the legislature and then a majority of the support of voters on the ballot. So they're going to have the 2/3 of the majority in each chamber. Why? Because the Republicans completely control the chambers. If the Democrats had at least 1 or 2 more votes that could block these things, it wouldn't become a constitutional amendment. And then they just need half the state to agree. And who knows when that election would take place. You probably want a low turnout election, so they'll probably plan it for a low turnout election, and then they'll hope that they can get it passed maybe during the runoffs for some of the seats that might have runoff elections for them. Boards and commissions. Governor would be able to appoint chairs and other officers of hundreds of boards and commissions as long as he sent notice to the affected groups within 20 days of taking office. Under legislation from Valerie Hodges of Denham Springs, his picks would also be subject to Senate confirmation. But of course, again, the Senate is just walking in lockstep behind Landry. They're not a check on his power. They are pushing for him to have more power, and they're just going to lie back and say, okay, whatever you want to do, we'll do. Like this is what you get also. Like if Donald Trump wins the presidency, how he says he wants to be a dictator from day one. Well, if he has the Supreme Court that backs him, and if he has 2 houses, both the House and the Senate, that also back him, he doesn't have to be a dictator in actual name. He could be a de facto dictator if the other branches of government that are supposed to be a check on his power ends up, not checking his power and instead just keeps on pushing for him to have more power, just like the Republicans in the state legislature here in Louisiana are doing for Jeff Landry. Let's see. Hodges said she had to talk about the governor about the bill. She was asked to draft it by an interested party interested in some of the same things that I'm interested in, who she refused to name publicly. If the Republicans are in control, and we are, conservative Republicans, then we should see that reflected in our boards and commissions. No. The boards and commissions should be apolitical and be reflective of the people, of all the people, and be, again, immune from politics, not shoved right full of politics. The Louisiana Supreme Court, this constitutional amendment by Mark Wright of Covington would give the governor the power to appoint Louisiana Supreme Court justices rather than having voters elect them. Wright's proposal expands the court from 6 to 8 and allows those currently on the bench to serve out the rest of their terms. Starting in 2025, the governor would get the power to replace each judge as their term expires. The governor's pick for the job would be subject to approval from 2/3 of the senators present for the confirmation vote. But again, the Senate is in just lockstep behind Landry, so that's no check on his power at all. The Senate would also be required to hold confirmation hearings, and the judges would serve 10-year terms, which is the current length. Of the current legislation to empower Landry more, this proposal seems the least likely to pass. It's a constitutional amendment which requires 2/3 of each legislator and then a vote of the people on the November ballot. Okay, so it is going to be the presidential election ballot. Many state lawmakers are attorneys and are unwilling to make even modest changes to the judiciary. Lawmakers are also moving new Supreme Court district maps in the current session on the assumption that the court's elections would continue. And the governor's mansion, HB 799, Vinny St. LeBlanc from Franklin, Louisiana, has filed a bill to weaken the authority of a commission that oversees the governor's mansion and its grounds in downtown Baton Rouge. Instead, the sitting governor would have more control over the facility. Proposal removes the mansion's commission's jurisdiction over the private areas of the house and its grounds and expands the parts of the residence that are off limits to the public. i.e., the public gets to get less access to the governor's mansion, and the governor has more control over what he can do with the mansion, whatever he wants, I guess. Additionally, the panel would also no longer have oversight over decorating, painting, renovations, rearrangement of furniture, art, and other significant changes. Instead, the governor's family could make those adjustments without its approval, i.e., they could do whatever they want with the historic building and not have to deal with oversight again, because the governor doesn't want to listen to anything that anybody has to say about anything at all. If you want to have a house and you want to design and build your own house and decorate your house to your own liking, get your own house. The governor's mansion belongs to the people of the state of Louisiana, Governor Landry, and there should be a check on your power to do whatever it is that you want to do with it. A member of the mansion staff, the executive residence director, would be removed from the commission and replaced with the chief of staff for the governor's spouse. A provision requiring the governor to consult with the mansion staff about who 3 of his appointees to the commission should be is also eliminated from the legislation. Under the proposal, commission members could be removed at any time by their appointing authority, which is either the governor, the spouse, or the spouse's chief of staff. It also repeals language passed in 2022 that would allow the commission to accept private donations to help with the upkeep of the mansion. So he wants to spend more government money on the upkeep of the mansion and doesn't want to accept private donations for it. What? I thought these people didn't like... Oh, that's right. They like spending government money as long as it's to benefit themselves. They don't like government money expenditures when they help other people. Higher education boards and higher education commissioners. Mike Fessy from Houma, Louisiana, filed legislation to give the governor authority to select the chairman of all state higher education boards and to pick the higher education commissioner. Currently, board members themselves pick their board chairman, and the Board of Regents, which has oversight over the statewide higher education policy, picks the higher education commissioner with a 2/3 vote of its members. Higher education board members serve staggered terms, which means Landry is unable to replace all the board's members appointed by former John Bell Edwards for a few years. But still, again, he gets more power with less oversight. More power with less oversight is bad, regardless of who it happens to. But here in Louisiana, we're seeing what happens when we have a complete and total government that's completely and totally run by Republicans. But wait, there's more. Because this is not just about the boards. This is not just about who Landry gets to appoint. This is also about open records laws. They don't like open records laws either. A bill filed in the Louisiana Senate would eviscerate the state's open records law by blocking from public view emails, text messages, and other documents produced at all levels of government, from the town hall in Waterproof to the governor's office in Baton Rouge. The bill, carried by Senator Heather Cloud of Turkey Creek, is one of 3 filed by Republican state lawmakers on Tuesday, and that would add transformative new hurdles to the process of obtaining documents and other records from official government agencies. Some of the provisions are tailored to the office of Governor Landry, a Republican in the past who has bristled at scrutiny leveled through the process. Cloud's Senate Bill 482 goes the furthest of those bills by gutting from the list of records eligible for public access all documents that detail, quote, deliberations in government work. It would exempt documents containing advisory opinions, recommendations, and deliberations, and none of these people like the Oxford comma, that feed into government decision or policy-making choices. Watchdog groups and attorneys dealing with the public information issues decried the bill. Malia Serrato, a Sunshine legal fellow at Tulane University's First Amendment Law Clinic, called it extremely alarming and that it risks violating the state's constitution. But who the care? If Landry gets to name the people on the Supreme Court, and Landry is probably going to put people on the Supreme Court who are going to agree with Landry's opinions, they'll probably be like, yeah, this is fine, no problem here. This will create government secrecy on a level that should alarm people regardless of where they are on the political spectrum. This is bad government. But again, as we've seen in discussions where people go interview Trump supporters, they ask about Trump wanting to be a dictator, and these Trump supporters who claim to love America, claim to love the country, are like, well, maybe we need a dictator for a little bit just to fix things in this country. Well, I'm sure the same people will think the same thing about Jeff Landry as well. Cloud, in a text message, she was traveling and unable to fully comment on SB 42. 2 more bills filed near the deadline propose more hurdles for the public records process. Senate Bill 423, and we'll go perhaps over those a little more in detail, sponsored by Jay Morris of West Monroe, would only allow Louisiana residents to make such requests, i.e. if you're harmed outside of Louisiana, let's say you live in Texas or Maryland or California, and if you're harmed by something that Louisiana did and you want to make a public record request, guess what? Too bad you can't do it according to this law or this proposed law, because it could only be made by people who live in Louisiana. And then Senator Blake Miguez's SB 502 would require ID checks on people who make requests, because they want to make sure that you are who you really, because they want to make sure they know who's asking questions. Because if they know who's asking questions, they can come after the people who are asking the questions. In an interview, Miguez said his bill aims to cut down on what is described as the proliferation of requests sent by nameless people to government agencies. Miguez suspects some of those requests come from people with political motives. He said, who cares? Who cares if there are political motivations behind the public records requests? They're public records requests for a reason, and they should be made available to the public because, this information should be public record. And you shouldn't be trying to hide information from the public, because the moment you start trying to hide information from the public, guess what? The public has less and less reason to trust you. But as we're seeing now, the public in Louisiana seem to have no problem with trusting the Republicans enough to give them a supermajority in both houses and the governorship on first vote. Journalists, business people, and officials who request access to public documents should still be able to obtain them. He said, now they have AI. They have programs that can go and hit every agency head with all these requests and wave him down. Oh, well, too bad. If you feel weighed down by doing your job, maybe somebody else should do that job then if they feel weighed down by the requests for public information. Morris did not return messages Wednesday. His bill risks angering out-of-state businesses who sometimes require public records as they draft deals for new ventures in Louisiana, said Stephen Procopio, head of the Nonpartisan Public Affairs Research Council of Louisiana. You're making companies jump through hoops to try and come here. That probably wouldn't kill a deal, but it wouldn't look good. Kate Kelly, the governor's press secretary, said lawmakers filed dozens of bills in the hours before the deadline, and Landry's staff is still sifting through them. Of course, none of them were probably proposed without passing them through Landry's office first, so the idea that they're still sifting through them is full of malarkey. No malarkey. Miguez said he filed a version of his public records bill in past term when it faced a tougher path with Democrat John Bel Edwards as governor and fewer conservative allies for him to lead on in the legislature. Landry, the state attorney general at the time, supported the bill then, said Miguez. Well, of course he did, because he doesn't want people looking into his stuff. Because there are certain rumors that I've heard of that I'm not going to really talk about right now of what his past might include and, what public records might be included in them. But we're not going to go that far as to expound onto which, because I want more than just rumors. But there were rumors about David Vitter too, and those rumors came true. Because every conservative accusation is an admittance of guilt. So it seems, at least. Cloud's bill resembles a measure filed last month in the State House that sought to exempt those same deliberative records produced by the governor's office from public records. Representative Michael Mellerine from Shreveport, who sponsored the bill, said he had conversations with Landry's staff about the bill, but declined to say whether the governor had pushed for it. I think we can all assume that Governor's Landry office pushed for the bill. Asked if Landry supports her bill, Cloud said in a text message, "I sure hope so." The exemption for deliberative records has spurred debate in recent Louisiana governor's administrations. Governor Bobby Jindal backed a law in 2009 that would have allowed his office to hide under similar exceptions. Jindal sold the measure as a tool to subject the governor's office to sunshine rules that hadn't applied to it in the past. His aides and appointees used it instead to shroud executive branch agencies in secrecy by claiming that certain requested records were part of deliberative policy discussions and thus off limits. Lawmakers agreed to reverse the rule after Jindal left office. So now they want back at it again because, now you have a Republican governor. Governor supported a bill in a February special session to reveal some youth court records in the name of transparency, despite blistering pushback from advocates who warned it would leave a mark on children accused of crimes. And Wednesday, Landry's Twitter account posted an interview with the Epoch Times. Of course, he has an interview with the Epoch Times. Why wouldn't you have interviews with the Epoch Times, a right-wing publication backed by the conservative Chinese Falun Gong movement, in which Landry discussed our continued fight to protect Americans' First Amendment rights. Except for, when those rights that Americans have interfere with your ability to hide your bogus BS, Governor Landry. At the same time, the governor's office supported efforts to pare back access to death penalty records through a bill in February special session that's set to shield lethal injection drugs from public view. So we can't know what drugs are being used to kill people as part of the death penalty in Louisiana, but we can know which children were accused of crimes even if they weren't convicted of them. Again, that's a bunch of malarkey. More on these bills. The Attorney General left Jeff Landry sues advocate reporter over public records request. The Louisiana Attorney General left Jeff Landry, back when he was AG, sued a reporter for the Advocate and Times-Picayune over a public records request she filed asking a judge to issue a declaratory judgment denying the request and seal the proceedings. The unusual action came a few days after the newspaper warned Landry that it intended to sue him if he didn't turn over the requested records. In my 40 years as an editor, I've never seen a journalist get sued for requesting a public record. We are not intimidated. In fact, we're more determined. The matter dates to December 14th, when the reporter, Andrea Gallo, first filed a public record request, with Landry's office seeking copies of sexual harassment complaints against Pat McGee, the head of the office's criminal division, and records of how the complaints were handled. McGee was placed on administrative leave pending an investigation that day. So it's okay to hide information about somebody who has been accused of sexual harassment, but it's apparently also okay to let everybody know if a kid has been accused of a crime but not convicted of one. January 4th, attorneys in Landry's office reiterated that the reasoning for withholding the documents was temporary, not permanent. We'll make the appropriate documents available once the investigation is over. Landry's office hired Vicky Crochet of the term Taylor Porter to conduct the investigation. McGee returned to work January 19th after investigation found that he had engaged in inappropriate verbal conversations, used sexual slang, and made unprofessional comments over the appearance of employees. Landry's office ordered McGee to take a one-time $20,559 salary reduction and directed him to take courses on workplace professionalism and conflict management. So we would invite the redaction of the initial complaint to protect the identity of the victim, but that is the only privacy interest even arguably applicable, Attorney Scott Steinberg, who represents the Advocate Times-Picayune, told Landry's office in a letter, because they were claiming that they were trying to protect the victim. But do you believe that? I don't believe that. You shouldn't believe that either, because Landry is unbelievable, i.e. somebody who's not to be believed and not unbelievable as great or wonderful. Let's see, again, so Senate Bill 42 by Heather Cloud, the original text of the legislation. To enact RS 44464 and 41.e and repeal RS 445B4 relative to public records, to prohibit access to records of the office of governor pertaining to the security of the governor's family, and an exception to the public records law of any records involving opinions, recommendations, and deliberations. Oh, she used a Oxford comma there. In formulating decisions or policies, and to provide for related matters. This chapter shall not apply to any record of the office of governor pertaining to the schedule of the governor or the governor's spouse or child that contains security details that, if made public, may impair the safety of the governor, his spouse, or the child. And if that's all that was, then fine. If there are certain information that you want to keep any governor protected because you don't want people knowing, like, this is where the governor's spouse or child is going to be, maybe I could agree with that. But then the provisions of this chapter shall not apply to any records reflecting advisory opinions, recommendations, and deliberations comprising part of a process which governmental decisions and policies formulated. That's a bunch of BS. There's no reason that we should be putting that into place, because those parts should absolutely be part of public view. Everybody should be able to know what's going on in the actions that pertain to our government and the running of it. SB 423 by Jay Morris. Could check out the original of this one real quick. Doop-a-doop-a-doo. Provides for access to public records by certain persons. A legislator recognizes that it is essential to the maintenance of a democratic society that public business be performed in an open and public manner, and that citizens of this state, which is the additions, should be advised and be aware of the performance of the public officials and deliberations, decisions that goes into making. So this law says it's important to know about the deliberations and decisions that go into making public policy, but the other one is going to say you can't see those anyway. So this one is going to be there just in case the other one fails. If the other one fails and stops you from learning about the deliberations and decisions going to making public policy, you'll have this one that says, well, only citizens of this state. So it's not even residents, as the media reported it, as the article in the newspaper said. It was for residents of the state. No, citizens of the state. So if you live here but are not a citizen of the state, you can't make a public records request either. The provisions of subsection B of the section shall not prevent any, and they cross out person, and they say Louisiana citizen instead, from inspecting, examining, copying, or obtaining an electronic or physical reproduction of any record pertaining to any money or monies or assets or items of economic value to the state, or any financial transactions in control or handled by or through the governor, yada, yada, yada. Again, later on, any person is scratched out, and Louisiana citizen is replaced with that. May obtain a copy of reproduction of any public record. Exceptions for purposes of this chapter: Louisiana citizen does not include an individual in custody after a sentence following felony conviction. So apparently if you have a felony, you can't make a public records request? What? The custodian may make an inquiry of any individual who applies for a public record to determine if the individual is in custody after the sentence following a felony conviction, who has exhausted his appellate remedies, and the custodian may make any inquiry necessary to determine if the request of any individual in custody for felony conviction is limited to grounds in which the individual may apply for post-conviction relief under the Code of Criminal Procedure. The custodian shall prevent any public record or present any public record to any Louisiana citizen of the age of majority who so requests. Custodian shall make no inquiry of any Louisiana citizen who applies for public record except an inquiry as to the age and state-issued identification of the Louisiana citizen. Can't be any other issued identification. So apparently, you can't use a passport to get a public records request, because it has to now be, it will now have to be a state-issued identification. So if you are a Louisiana resident who doesn't have a state identification for whatever reason, but use your passport for everything, you won't be able to get this, because they could get around it by saying, well, you don't have a Louisiana identification, so therefore, too bad. Now, in reality speaking, anybody can get a free Louisiana voter ID. Still, you shouldn't have to be a citizen and a voter to make requests from our government. This bill is actually longer than the last one, but it's pretty much just showing the existing law and then shoving in, most of the, okay, there's another place where they replace persons with Louisiana citizens. Any Louisiana citizen may request a copy, reproduction, or public record, blah, blah, blah. Editing out such for the, again, more editing out of persons for Louisiana citizens, yada, 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 so on and so on and so forth. That's what most of this does for the rest of the legislation, the rest of the bill. The digest of the bill at the bottom of the bill. Present law provides that the legislature recognizes that it is essential for the maintenance of a democratic society that public business be performed in an open and public manner, and that the citizens be advised and aware of the performance of public officials. Toward that end, the provisions of present law shall be construed liberally to facilitate rather than hinder access to public records. Present law provides that present law shall now prevent any person from inspecting these records. What's the proposed law? Let's see what they say about the proposed law. A proposed law retains present law and requires any public record of the requester to be a Louisiana citizen, i.e., can't be a resident, can't be somebody from somewhere else. Again, more ridiculousness coming from our Louisiana legislature that, again, is fully run by Republicans. And as such, they're going to try and put up as much political cover for this governor as they can. The last one, notwithstanding any provision of the whatever section to the contrary, the custodian or his employee shall require any Louisiana citizen requesting to copy, inspect, or reproduce any public record to provide sufficient information to establish the age and identification of the citizen making the request. For purposes of this subsection, sufficient information shall include any electronic or physical document or identification card which holds the requester's name, photograph, and other identifying information, and if the requester is a legal entity or acting as the agent of a legal entity, sufficient information shall also include the legitimate name and physical address for the legal entity, which is why you can't use a passport from the last law, because they want your address. If a Louisiana citizen requesting to inspect, copy, reproduce any public record fails to provide sufficient information as required in this section, after being requested, neither the custodian nor his employee shall be required to produce the requested records in accordance with the provisions of this chapter. Any document submitted to establish the age and identification of the citizen pursuant to the subsection shall not be a public record pursuant to the provisions of this chapter. I can agree with that. I can agree with the idea that if I give you a copy of my driver's license, that in order to make a public records request, that the copy of my driver's license should not be allowed to be used as a public record. I am fine with that. Probably the only thing in these laws that I'm fine with, and maybe a little bit on the governor's safety of his family. Subsection shall not apply to any Louisiana citizen actually confined in a correctional facility pursuant to an order of imprisonment, making a lawful request pursuant to the provisions of RS 4431. Present law provides that all books, records, writings, accounts, letters, letter books, maps, drawings, photographs, cards, tapes, recordings, memoranda, and papers, and all copies of duplicates, photographs, including microfilm and other reproductions thereof, yada, 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 yada. shall be our public records. Present law establishes a framework for the ready availability of public records and how anybody can request those records. Present law provides that a custodian shall make no inquiry of any person who applies for a record, except for an inquiry as to the age and identification of the person. Proposed law authorizes the custodian or his employees to require any Louisiana citizen requesting to inspect, copy, reproduce, blah, 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 to give sufficient information, and it defines the idea of sufficient information. These laws are being made so that it's going to be easier and easier for Governor Landry and anybody other Republican in this legislature to be able to hide what they're doing. They don't want us seeing what they're doing. And if they don't want us seeing what they're doing, we all have to question why. And again, I don't just bring this up on my show that's typically about national politics to do a focus just on Louisiana. I bring this up because this is what government looks like when it's fully run by Republicans. This is how you start fascism, and what is happening in Louisiana will happen nationwide if Donald Trump is allowed to win office and we give him a Republican-controlled legislature in both houses so that Donald Trump can just do whatever it is that he wants to do and be a dictator from day one. Just like Landry is trying to be a dictator from day one by passing all of these bills that are meant to make government worse. Republicans will tell you that government is the problem, and then they get elected to government and show you why it's the problem. But in this case, they're going to be using government to benefit themselves and to benefit their future political ambitions and goals, and to basically test probably anything that does manage to get passed in order to make sure that, you know, we could test it maybe against the Supreme Court. So when Trump tries to do it, he'll be like, oh, this is fine. Louisiana can do it. We can do it too. So this is why you never go full Republican, everyone. And I'm speaking to, preaching to the choir for most of the people in the chat, but this is going to be its own standalone video. And so when you see this as its own standalone, share it with everybody and let them know what is going on here in Louisiana. How Louisiana is going to slide further and further into fascism, for more and more into problematic government, and it's going to show you exactly what the Republicans intend to do on a grand scale because they're doing it now at this level. What are your thoughts? Leave your comments below. Remember to like the video, share it, subscribe to the channel. Thank you very much, and have a good day.